White people have had a 400 plus year head start. 400 years worth of generational wealth stolen from our ancestors, Native Americans, ancestors, mind you, stolen. They didn't earn it, took it. And have had a 400 plus year head start and generational wealth. And they can't even handle Black people having one full generation of bare minimum voting right access.
Hi lovelies, welcome back to my channel. If you're new here, my name is Belinda Strana. Thank you so much for all the love and support. To my returning subscribers, those people that share my videos, leave commentaries, and also educate each and every one of us, you guys are the real MVP. Today's story has a lot of people, especially in the Black community, speaking up, questioning the direction America is heading. The Supreme Court's recent decision to weaken Section 2 of the Voting Rights Act has sparked major outrage, confusion, and fear about what this means for the future of democracy, and more importantly, Black voting rights. Let's get into how Black Americans are actually reacting to these recent findings about, Supreme Court's decision that, they're about to take the certain decision. I'm just going to roll it. Please leave me your own thought in the comment section of what you think of this video, and let's dive into it.
White people have had a 400 plus year head start. 400 years worth of generational wealth stolen from our ancestors, Native Americans, ancestors, mind you, stolen. They didn't earn it, took it. And have had a 400 plus year head start and generational wealth. And they can't even handle Black people having one full generation of bare minimum voting right access. Bare minimum. We ain't even nowhere near the same level what y'all got. We just talking about voting rights. My grandmother is almost 80. And in her lifetime, she has literally gone from Black people hardly having any voting rights, especially Black women, to gaining a semblance of voting rights, to now those voting rights being back on the chopping block in one lifetime span. Grandmother. It is so enraging. It's giving me goosebumps. And white people, I don't want to hear y'all in my comments. I'm so sorry that y'all are experiencing this. This is so unfortunate. I voted for Kamala. I don't want to hear it. I don't want to see a speck of salt in my comments. I'll delete it. I don't want to see y'all right now. I don't care about your condolences. I don't care. I don't want to hear it. I'm sick of y'all. I'm so Jesus. 400 year head start, and y'all can't even handle. This is just.
The Supreme Court hears arguments this morning in a case that could undermine one of the last surviving parts of the Voting Rights Act. Now, that is one of the country's most important civil rights laws.
The court here today is going to be focused on part of that law that can require states to draw up legislative districts that sometimes zigzag across the state to group together voters based on their skin color. This is all to increase minority representation, and the court's decision could have sweeping implications nationwide.
It is really troubling for anyone to pretend that race is not an unbelievably loud issue in our country right now.
Civil rights advocates like Ashley Shelton say now is not the time to gut Section 2 of the Voting Rights Act and end the use of race in redistricting.
We cannot pretend that there isn't going to be considerable loss of minority voice and power if we were to do away with Section 2.
Advocates credit Section 2 with increasing minority representation nationwide by requiring states to draw some districts that are majority Black, like this congressional map in Louisiana. But critics say Black candidates are winning in Louisiana and elsewhere in non-minority districts, and grouping people based on their race only fuels divisions.
I think it's time to give people a chance and to continue to vote for people based on their character and their fitness for office.
Louisiana Attorney General Liz Murrill says the case shows how states are in an impossible position. 3 years ago, civil rights groups, including Shelton's, sued under the Voting Rights Act to get a second black district and won in court. But after Louisiana drew up the new map, a group of white voters sued, arguing the new minority district was unconstitutional because it considered race.
The Constitution has told us to not sort people by race. The courts have told us we can't sort voters by race. And yet we are being told to go out and sort our voters by race.
Now, the court has restricted the use of race in other areas, such as when it ended affirmative action in college admissions. And if the justices use that reasoning in this case, that could really change the rules for how states draw up their legislative districts. The political implications could be huge, including in those current redistricting efforts for the midterms, possibly as soon as next year.
Countless black people were hung in trees, burned, tarred and feathered, shot, imprisoned, exiled for the Voting Rights Act. As soon as you peep their game, they attack. This week, the Supreme Court was back at it, and it looks like we're staring down yet another blow to black voting power in this country. Imagine that. We are the target. Again. Now, if you know your history like I know my history, you know that the Voting Rights Act of 1965 was a major win for the civil rights era. It was meant to protect us from the racist voter suppression tactics that had been the norm for so long. But here's the problem. Over the past decade, this law has been slowly picked apart by the Supreme Court because the Supreme Court has been slowly growing more conservative. And this week, the justices heard a new case that could cut even deeper into our already fragile voting protections. So this all started with the state of Louisiana, which has a black population of about 30%. After the last census, the state was required to redraw its congressional maps. That's normal. But here's the catch. After a lot of legal back and forth, Louisiana was told it needed to create 2 majority black districts to fairly represent the state's black voters. Eventually they did. But then not out of nowhere, a group of so-called non-black voters jumped in and said, hold up, we've got a problem with that. Mind you, not the black folks, not the legislature, not the court, but this group didn't like the idea of adding a second black majority district. So they took it to court, and now it's in front of the Supreme Court, because that's what happens when white folks get upset. What's wild is that we've been here before. Just 2 years ago, this same court, with Chief Justice John Roberts writing the opinion, upheld a very similar provision of the Voting Rights Act in Alabama. They said, yeah, if black voters are being packed into one district or spread out to dilute their power, that's not okay. That decision gave folks a little bit of hope. But now Roberts is acting like that case doesn't even matter. Like it's not exactly the same. Like it was a one-off. During arguments, the court's conservative justices made it pretty clear they were leaning towards limiting protections for black voters. Again, Justice Alito tried to argue that chasing partisan advantage isn't the same as using race. But come on now. In places like Louisiana, race and party are so tightly connected, you can't separate the two. Lawyer Nielsen, president of the NAACP's Legal Defense Fund, told the court straight up, we're talking about racially polarized voting that is above 84%. Translation, the vast majority of white voters in Louisiana simply don't vote for black candidates, no matter their party. This ain't just political, it's racial. But they don't want to admit that. And then we had Justice Barry Kavanaugh, the rapist, who cast the deciding vote in that Alabama case 2 years ago, come in talking about how race-based remedies like this shouldn't last forever. You're right, Brett. It should last as long as all of y'all are racist. But Nielsen reminded him, Congress didn't put an expiration date on this part of the Voting Rights Act. And more importantly, the 15th Amendment, the one that bans race-based voting discrimination, that's permanent because y'all can't be trusted. Ain't no sunset clause on that because y'all have always been racist and you will always be racist. Justice Kagan asked the question that's probably on your mind right now. What happens if the court guts this part of the Voting Rights Act? Nelson didn't hesitate. She said it would be catastrophic because it would. The reason we even have black congressional representation in the Deep South is because of these protections, people. If they get tossed, the map, literally and figuratively, gets a whole lot worse for black folks. We've got to keep organizing, keep voting, keep fighting in the courts and everywhere else. We've got to keep showing up for each other, even when the system tries to shut us down. Keep your people informed and share this video with anyone who needs the information. This isn't just about maps. It's about power. And we know they don't give it to us. We have to take it by any means necessary. But you need to be educated on how the game is played. You need to be disciplined to play the game to win. And you have to have empathy for your brothers and sisters who don't yet know everything they need to know. I love you, black man. I love you, black woman. Knowledge is power. Power to the people.
Listen to this. Listen to this. This is Justice Jackson talking to the attorney that is arguing for the state. This is what I was talking about in my clip earlier. And she got frustrated talking to him because he's acting like the solutions are the issue, but he's not acknowledging why the solutions are race-based if the problems are race-based. Listen to this.
Justice Jackson.
So where in Section 2 does it mandate another minority district? I mean, my understanding, as I explored with Ms. Nelson, is that Section 2 is the mechanism by which we determine that equal electoral opportunity is not being provided for a certain minority group. And we've interpreted in jingles, we've given some flesh to how one goes about identifying that set of circumstances. But I thought that's the end of it in terms of the court's announcement under Section 2, and the court then turns to the state and says, how do you want to remedy this? We've got a problem. And sometimes the state might draw a second minority district, sometimes it might not. And yet your answer to Justice Barrett was, well, everybody just knows that that's the automatic remedy. So can you help me figure out that disconnect?
Well, Justice Jackson, I think there's a reason why this court's voting precedents going all the way back to Shaw 1 are so tied up with race. It's because the remedy, as parties and the courts have understood Section 2 to operate, is almost always going to be race-based. That's why
they're so tied up with race because that's the initial problem, right? That's the beginning. The beginning is the claim that a person makes under Section 2 that because of their race, they are not being afforded equal electoral opportunity. It is a separate question as to how we go about remedying that and the extent to which we need to use race as a remedy. That's the question we're here on today, but the Section 2 issue is just what circumstances do we look at to determine whether this problem of unequal electoral opportunity on the basis of race is occurring.
Right, and a couple of responses to that, Justice Jackson.
Wait, Phil, can I just ask you, why is that not a compelling state interest to identify areas in which that problem is occurring?
Your Honor, of course, as this court recognized in SFFA, states can remedy intentional
No, I'm not talking about the remedy. I'm talking about
identify.
All right, so if I'm right, that Section 2 is about identifying the problem and then requiring some remedy, I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue,
Exactly.
right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No, it's
majority black
not.
district.
This is a lawyer. He said, and that is just he basically interpret their words for them as in saying, we want another black district. Not the fact that he didn't think of, we are receiving unfair treatment and we need to find a solution to it. He doesn't want to acknowledge the system that is race-based in the favor of white people.
As we speak, the Supreme Court is reviewing the Voting Rights Act of 1965. The Voting Rights Act of 1965 was one of the most powerful civil rights laws ever passed in the United States. It gave black people and all people the right to vote. It actually protected them because they were unfairly blocked for decades from voting. Before the law, many black people were threatened, beaten, and denied the right to vote. They had no rights. They had no vote. So in 2025, after all this progress he made, the Supreme Court wants to review this law? So what is the mission, Supreme Court? Someone help me the fuck out. What is your purpose now in 2025 to look back at the 1965 Civil Rights Act for voting? You're going to fucking determine that they were wrong then and you don't need it fucking now? You need it more than fucking ever because it's called Jerry fucking Mandering. They're taking people's rights of representation, and the minorities, which are black people and all people, don't have any fucking representation.
The Trump administration is planning to rehaul the U.S. refugee system to favor white people. Yes, you heard that right. The news comes one day after young Republican leaders were caught sending racist messages on a group chat. Yet some Republicans are pretending like they have no idea where the racism is coming from. The call is coming from inside the House. In January, Trump repealed a 1965 civil rights order that banned racial discrimination in the federal government, and he blamed DEI for a plane crash in Washington, D.C. In February, Trump banned Black History Month events at several federal agencies and fired General C.Q. Brown, the black chairman of the Joint Chiefs of Staff. In March, the Trump administration rehired a 25-year-old official who had been fired after he bragged about being a racist. In April, Trump removed references to Harriet Tubman from the National Park Service website. In May, Trump welcomed only white South Africans to move to the United States while punishing the country's black majority government. In June, Trump announced that U.S. military bases will be renamed after racist Confederate generals who supported slavery. In July, the State Department hired a staff member who said that competent white men must be in charge if you want things to work. In August, Trump announced he would put up a Confederate statue in Washington, D.C. In September, Trump removed a photo of slavery from a national park exhibit. And in October, on the same day when the racist text messages were published, Trump gave a Presidential Medal of Freedom to the late Charlie Kirk, a white conservative who claimed that the Civil Rights Act was a mistake and Dr. King was an awful person. And just today, the Trump administration is at the Supreme Court asking the justices to eliminate a black congressional district in Louisiana and weaken a key provision of the Voting Rights Act. This is just a partial list from 2025. So yes, the racist group chat is not surprising. And it's sad but not surprising that Vice President J.D. Vance refused to condemn it. But as Frederick Douglass warned centuries ago, the white man's happiness cannot be purchased by the black man's misery. Douglass, a proud black Republican of the 19th century, would be ashamed of what the grand old party has become in the 21st century under Donald Trump.
So, lovies, across all the social platforms, like places like Twitter, Instagram, and thereabout, so many people are reacting to the fact that there is a major setback for civil rights, one that echoes the struggle their parents and grandparents fought against during the 1960s. Section 2 of the Voting Rights Act was one of the most powerful tools for challenging racial discrimination in elections. It actually allows lawsuit against state or local government if they create voting laws or districts that dilute minority voting power. But now, by cutting this section, the Supreme Court has made it much harder to challenge racial bias in voting maps or suppression tactics. Many black commentators are saying this ruling is not just legal, it's political. They see it as a move to weaken the collective power of black or minority voters, especially in the key states like Georgia, Alabama, and Texas. You've got people online saying these things like our ancestors fought and died for this right, and now we are watching history repeat itself in broad daylight. And others are expressing deep frustrations that some courts that claims to protect democracy seem to be undermining of its core foundation, equal access to the ballot. Many civil rights activists and black political leaders are comparing this to the Shabbat Court Review Holders decision back in 2013, right? When the court removed the requirement that states with a history of discrimination had to get federal approval before changing their voting laws. They say that decision opened the floodgates for voter ID laws, polling places closure, and all of which hit black and minority communities harder. Now, with Section 2 gutted, people fear the last real safeguard is gone. A lot of black Americans are also talking about how this ruling exposes the double standard in American justice. They also point out that the same system that pushes or punishes minor offenses harshly is now erasing protection for one of the most scared rights, the right to vote. Some younger black Americans are expressing disillusionment, saying, "What's the point of voting if the system is actually designed to silence us?" But others are pushing back with hope, saying this is exactly why it's important to stay engaged, organize locally, and keep showing up at the poll. Many political analysts in the black community warn that this decision could reshape future elections. Without Section 2's protection, states can redraw maps or implement laws that subtly exclude minority voters, and it will be much harder to prove discrimination in court. This isn't just a legal issue, it's a moral one. People are actually saying or asking, if America claims to be the land of democracy, how can it keep rolling back the very law that ensure everyone has a voice? So commentators have even gone as far as saying this is part of a broader effort to consolidate power among the wealthy and white political elite, reducing the influence of diverse working class communities that often vote differently. There are also a cultural undertone here. Many black Americans feel this ruling is a reminder of how fragile progress can be. One viral TikTok put this way: they don't need to use horses and dogs anymore. All they need is a pen and a rope. That line resonated deeply. It reflects the idea that modern racism doesn't always look like it did in 1960s. It's coded into politics, court ruling, and legal loopholes. Community voices are urging unity, civic education, and awareness. Some activists are launching online campaigns, encouraging people to check their voter registration, stay informed, and about local election laws, and support organizations that defend voting rights. At the end of the day, this Supreme Court's ruling feels like it actually feels like a wake-up call for many people in the black community. The message is actually clear. The fight for equal voting rights isn't over. It's just entering a new chapter. Because if these people should actually push, if the Supreme Court should actually push for this voting right to athlete, it is not only that they are just trying to rub all of the fight that was fought by the ancestors into the mud, but they are just trying to look for ways to cut off people's voting power. Anyway, lovelies, when I saw this, I thought that I was just gonna chip it up here because this actually got the whole of the social platform reacting to the fact that if this should actually go through, it is it's a no-no, and it's just gonna be the end of it all. Why not just leave me your own thoughts in the comment section of what you think of this video. And please do not forget that we do not support any form of bullying and harassment. We are just here for educational and informative purposes. So what do you think about this ruling? Do you feel like democracy is being protected or eroded? Let's talk about it in the comment section. And if you are new here, don't forget to please like, subscribe, and hit the bell for more real talks and reactions every day. Until next time, stay away, stay strong, and stay united. I love you guys, and I'm signing out. That's Belinda Strand. Give me your own thought in the comment section of what you think of this video. Please do not forget that we do not, support any form of bullying and harassment. We're just here for educational and informative purposes. So please share this video, subscribe, leave a thought, and I will see you lovely when I upload the next one.